I would dare say that looks like it's what Chris is I see Congressman Evans also has the same hue of color. So.
Oh, wow, DE, I didn't guess. And you?
Madam Chair, council members, and distinguished participants, we are now.
Thank you. I understand that state law currently requires that the following announcement be made at the beginning of every remote public hearing as follows. Due to the current public health emergency, City Council committees are currently meeting remotely. We are using Microsoft Teams to make these remote hearings possible. Instructions for how the public may view and offer public testimony at public hearings of council committees are included in the public hearing notices that are published in the Daily News, Inquirer, Legal Intelligencer, prior to the hearings, and can also be found on phlcouncil.com. I now note that the hour has come. Rachel, will you please call the roll to take attendance? Members that are in attendance will please indicate that you are present when your name is called. Also, please say a few brief words when responding so that your image will be displayed on the screen when you speak.
Vice Chair Derek Green.
Present, looking forward for a great conversation in today's law and government hearing.
Councilmember Helen Gim.
Present. Thank you, everybody.
Councilmember Maria Quinones Sanchez.
Present. Thank you.
Councilmember Mark Squilla.
Present. Good morning, Madam Chair and colleagues. Good afternoon. Sorry.
Good morning.
And those are all the members in attendance right now.
Thank you. A quorum of the committee is present, and this hearing is now formally called to order. This is the public hearing of the Committee on Law and Government regarding bill numbers 200252 and 200159. As the sponsor of Bill 200413, I will be holding that bill in committee today without hearing it. Instead, it will be heard in November. This will give me time to work with the law department on important technical amendments. It will also give me time to introduce a companion bill that will further improve the law that's on the books. With that being said, Rachel, will you please read the titles of the bills being heard today?
200252, an ordinance amending Chapter 9-1100 of the Philadelphia Code entitled Fair Practices Ordinance, Protections Against Unlawful Discrimination, to clarify that unlawful discrimination includes discrimination based on characteristics such as hair texture and hairstyles, all under certain terms and conditions. 200159, an ordinance amending Chapter 9-800 of the Philadelphia Code entitled Landlord and Tenant to clarify and amend applicable procedures pertaining to the Fair Housing Commission and to provide for the adoption of regulations, all under certain terms and conditions.
Before, yes.
Madam Chair, Councilman O'Neill, I don't know if you took roll yet. I was having trouble getting on, but I'm here.
Thank you, Councilman O'Neill, duly noted. Rachel, please note Councilmember O'Neill's attendance for the record. Before we begin to hear testimony from the witnesses we have for today, everyone who has been invited to the meeting to testify should be aware that this public hearing is being recorded. Because the hearing is public, participants and viewers have no reasonable expectation of privacy. By continuing to be in the meeting, you are consenting to being recorded. Additionally, prior to recognizing members for the questions or comments they have for witnesses, I will note for the record at this time that we will use the chat feature available in Microsoft Teams to allow members to signify that they wish to be recognized. In order to comply with the Sunshine Act, that the chat feature must only be used for that purpose. Before I ask Rachel to call the first panel for bill number 200252, I would like to make some opening comments. On March the 12th, we had COVID shutdown, breathing down our necks. I was proud, very proud to introduce what is effectively a local version of the Crown Act. And for those of you who don't know, CROWN is an acronym that stands for Creating a Respectful and Open World for Natural Hair. Bill number 200252 amends the code to clarify that unlawful discrimination on the basis of race includes discrimination based on characteristics commonly associated with race, such as hair texture and hairstyles. This legislation will ban hair discrimination in housing, employment, school, competitive sports, and beyond. When this bill passes, Philadelphia will become the first city in the Commonwealth of Pennsylvania to adopt such a law, and joining a growing list of states and other jurisdictions that have either introduced or adopted legislation banning hair discrimination. I want to note for the record that I'm grateful to have our colleagues here in Congress. U.S. Congressman Dwight Evans is part of a coalition pushing to make this legislation a reality at the federal level, as is our senator, a neighboring senator from New Jersey, Cory Booker. And I want to give a special note of thanks to our colleagues from the Pennsylvania General Assembly, specifically PA House Caucus Chairwoman Joanna McClinton on the House side, and our Appropriations Chairman, Senator Vincent Hughes in the Senate. They have introduced similar legislation at the state level. I also want to thank the Commission on Human Relations, specifically Rue Landau, for her guidance and assistance in getting this legislation drafted. Now, for those of you who don't know, hair discrimination is still very much a reality for Black people. Early in 2020, a Black student in Pittsburgh was told that he would be suspended from school or even kept from graduating if he did not cut his locks. In October 2019, a Penn State University football player received a letter from an alumnus of the university stating that his, and I quote, dreadlocks look disgusting and are certainly not attractive. And there have been other recent high-profile instances at the national level, too, such as the New Jersey wrestler who was forced to cut his locks before he could participate in a match. And for the women, and I know we were all paying attention to this, actress Gabrielle Union, who was told on multiple occasions that her hairstyles were, and I quote, too Black and too ethnic for the show America's Got Talent. Now, as a Black woman, and I talked about this when I first introduced this legislation, there is not a Black woman in the world who does not have a testimony about sitting between her mother's legs, her grandmother's legs, her auntie's legs, or someone's legs, getting her hair done as a little girl, because they taught us it was very important to take care of your crown. And when we were children, we wore our braids and our hair was plaited. It was like almost standard operating procedure when I was growing up. But we have noticed that we have been forced to conform to mainstream standards of beauty for decades so that we can keep employment, so that we can work or live in a specific environment. And I am happy that we are now addressing this issue head on. I am proud to witness more and more women embrace their natural beauty and reject the need to fit into this, what I call the makeshift frame that once defined what beautiful and acceptable hair was. And for those who are watching who would think that this legislation is about hair, it's more than just hair. It's about culture. It's about accepting who we are and loving who we are. And no one should face discrimination because they are comfortable in their own skin and choose to identify with their culture. When I introduced this, I also noted at the time that my 8-year-old son, Langston, when he was 6.5, 7, asked to get his hair locked. Now, for Langston, this was not about a cultural expression at that age. He simply wanted his hair locked because he wanted to look like his father. The issue for me is now Langston wants a ponytail. And the sister who did his hair at that time, who first locked him, Philadelphia's cultural hair and just overall a standard of beauty icon, Sarita Scott from Duafe did that, whose salon is in North Philadelphia on 22nd Street. It did my heart well to know that if this legislative initiative is passed through council, Langston will be able to wear his locks, and were he fortunate enough for them to grow and become long enough so that he could get that ponytail that he wants. He will not be discriminated in school, in employment, and or in housing in this great city in which we live. With that being said, I want to thank my colleagues who co-sponsored this legislation, Council President Clark, Council members Gilmore Richardson, Thomas, Dom, O'Neill, whose son-in-law, who this issue is very dear to him, and Brooks, Jones, Squilla, Gaultier, Green, Gim, Bass, and Johnson. I also want to note for the record that during our first or second session of council, and I noted this on the floor when I introduced it, I looked around our chambers, and for a minute, I just noticed that 4 Black women in council members Brooks, Gaultier, and Gilmore Richardson, and myself, we were all rocking different expressions of hair. Brooks and Gaultier, they had the meticulously very well done cornrows and or braids. Councilwoman Gilmore Richardson was wearing what we refer to as the wet and wavy. I call it my travel style. And for me, I was wearing my dark black, ultra black yaki like I'm wearing now. Don't pull it too hard, but it helps me cover up the gray and do what I needed to do. But I noticed we had the freedom to do what we wanted to do relative to our hair and still be allowed to become members of our legislative body and not be discriminated against. So I look forward to making this legislation a reality. Rachel, will you please call the first panel scheduled to testify?
Madam Chair, before we go into calling the first panel, if you don't mind, I'd like to be recognized as president.
Thank you. Councilmember Bass is present for the record, and we will make sure that it is noted. Thank you, Councilwoman, for joining us.
The first panel is U.S. Representative Dwight Evans, State Representative Joanna McClinton, and State Senator Vincent Hughes.
Congressman Evans.
Okay, thank you.
Representative McClinton and Senator Hughes, good afternoon. You are connected. Please proceed with your testimony and state your name for the record.
Thank you. My name is Dwight Evans, and I'm a congressman for the 3rd Congressional District. And Councilwoman, I thank you for introducing this very important legislation. But you lost me a little bit when you start describing hairstyles, because I clearly have a hairstyle too, and it is my crown. Clinton Stanley Jr., a 6th grade old Black student in Florida, was excited and nervous to begin school. While most students worry about making friends or finding a seat at lunch, little Clinton would soon have a very different story. Arriving to school on the first day, 6-year-old Clinton was denied entry because of the dreadlock violation of the school handbook. A 6-year-old child was prevented from attending school because of his natural hair. This is not an isolated incident. It has happened in schools and offices all across this country. A recent study found that Black women face the hardest instances of discrimination, are more likely to be sent home from workplaces because of their hair. The studies have found that over 80% of Black women felt it necessary to switch their hairstyles to align with more conservative standards in order to work. I'm here to show support for the council chairwoman's proposed ordinance that would prevent discrimination on the basis of hairstyle. A 6-year-old student should not have to face this kind of discrimination. This is how I like to think of it. Your hair is your crown. Or in my case, your hair is your crown. It is not meant to be hidden. It should not be displayed. As a Black person, hair is a part of our identity. It's our honor and our culture and our history. For decades, we were told to be ashamed of our hair because it was too kinky, too curly, or too frizzy. It didn't fit straight. The hair of our white neighbors, our hair has been the subject of discrimination for years. After the abolishment of slavery, Black people felt pressure to fit into the white society. This meant trying to make their hair smooth and straight. Then during the civil rights movement in the 1960s, the Afro hairstyle became popular as a symbol of Black power. Around the same time, dreadlocks became more mainstream over the success of Bob Marley in the 1970s. And while hair wraps used to be a symbol of servitude during slavery, Black women started to reclaim their hair as symbols of Black power. Afros, dreadlocks, head wraps are all symbols of Black culture. Unlike other traditions such as skin color, hair is not a trait that is protected by the Constitution. Even though many have argued that hair is connected to a person's race and should be protected, the courts have disagreed with this alignment. And in 2016, the 11th U.S. Circuit Court of Appeal ruled that it is not discrimination to ban dreadlocks in the workplace. That is why your legislation is desperately needed. The Crown Act is critical to protecting Black Americans relating to discrimination. It should not be something that is taken lightly. So I applaud you and all the members of your council for showing this leadership. It is especially essential that you take this step and move forward. Yes, we at the national level have passed the bill out of the United States House and the Senate. And yes, I had Senator Cory Booker with me yesterday, traveling around to Philadelphia. Senator Booker, like myself, is on the Small Business Committee, and he, like you, recognized that something needs to be done. This city council should be applauded, and Councilwoman Parker should be applauded for demonstrating the leadership. As a late friend John Lewis said, when you see something that is not right, not fair, not just, you have to speak up. You have to say something. You have to say to do something. Hair discrimination has no place anywhere in America. I support Council Chairwoman Parker ordinance and ask this council to vote. I say this in conclusion, as the late John Lewis was said, let's get in some good trouble. Thank you on this initiative.
Thank you, Congressman. Caucus Chairwoman McClinton.
Thank you, Madam Leader, and good afternoon to my congressman where I live, Congressman Evans, and like 2 blocks from my house, Senator Hughes. Good to see you. And of course, Adjoa Amaswa, who's doing all the work on the national level. I'm trying to mute session because we're in session right now. And I have to thank my legislative staff for preparing some pretty remarkable comments, but I cannot read them all because you have quite the panels to follow. So good afternoon, everyone. I am State Representative Joanna McClinton. I represent the 191st Legislative District, and I am currently the Pennsylvania House Democratic Caucus Chair. It's a pleasure to be with you this afternoon and bring your attention to this very important issue that primarily, but not exclusively, affects African Americans. Let me first by recognizing and thanking all of the important folks who I did not mention, the chairwoman leading this effort for this committee and for this issue, the leader herself, Councilmember Sherelle Parker, your vice chair, and Derek Green, and all of your colleagues. Have you ever thought about changing your hairstyle for a job interview or been told that your hair is not professional or appropriate? Have you ever been denied access to a school social venue or a job solely based on your hair type or your hairstyle? Have you ever had to cut your hair before you could participate in a school sports activity? If not, consider yourself fortunate. Too many people of color, especially African Americans, are subjected to these types of incidents. Although strides have been made to eradicate discrimination, it still exists and there's more work to do. I'm happy to partner with Senator Hughes and introduce the Crown Act on the state level. And that being said, I'll just deviate momentarily. I know all through law school, I was very concerned about people not confusing me with the other Black girl. So I wanted to make sure my hair always looked the same. I always wanted to be professional. And then when I got out of school and started working as a public defender here in Philly, I wanted to make sure I looked old enough because all my clients said I looked too young. So I never once, in almost 10 years working as a defender, I never had an afro. I never had braids. I always had a nice press and curl look, or at the time, usually a relaxer, a wrap, because I always wanted to look the same and seem as professional as possible. And these were conscientious decisions I made when I sat in my hairdresser's chair. I was thinking about work. So if you don't have to think about that, then you don't realize how much we need legislation to ban hair discrimination, because it happens in so many forms. And when somehow I unplugged my flat iron 4 years ago, it wasn't even on purpose. And the council member, the leader, she was in Harrisburg, and she was, what you up to? I said, I don't even know what I'm up to. And then finally, I cut straight ends off, and my granny called me from North Carolina. What's your constituent say? I said, I haven't heard yet. Granny, I haven't heard yet, because my grandmother kept me in the kitchen with the hot comb, making sure it was none of this going on, because it was going to be this in a second. And she didn't want that before church, all right? So she made sure it was the opposite presentation to the world. But we're thinking about our presentation to the world in all of these different social settings, and we don't want anybody's child to be told they can't compete in a sport. We don't want anybody to not get a job before they interview based off of their appearance if otherwise professional and conforming to all the standards. So let me get back into this testimony, and I'll be wrapping up briefly. You can certainly review it a little bit later. So currently, I know you have heard or seen the recent events in which children and adults have been denied access to schools, participating in activities, and denied employment. And even at certain points, were denied access to the military simply because of their hair. This is why I've introduced House Bill 2725, also known as the Crown Act. That stands for creating a respectful, open world for natural hair. This legislation prohibits discrimination based on a person's hair texture or hairstyle. It identifies that when someone has a natural or protective hairstyle, then that is specific to our community, they will not be able to be discriminated against. The Pennsylvania Human Relations Act prohibits discrimination, but we want to take it a step further and ensure that no one can be discriminated against because of their hairstyle. Additional bills, of course, have been uplifted in City Council by the chairwoman, by our congressman down in D.C., and we're looking forward to moving the needle on this issue in Harrisburg so that not only is it important to our folks in Philly, but no matter where they are, in Scranton, in Jefferson County, in Erie, Pennsylvania, there will not be any family, any child, any woman discriminated against by how they present their hair, whether it's in a lock style or whether it's a twist out or whatever it might be. And so that being said, Madam Chair, thank you for this time. We do have caucus in a little bit, so I'm not going to talk. Y'all not going to say that was me today, but thank you for this privilege. And with that, I'll turn it back over to you.
Thank you, Caucus Chairwoman McClinton. Oh God, what a star. Our Appropriations Chairman, Vincent Hughes.
Councilwoman Parker, and all my colleagues, thank you. Not sure what's left to be said after these two individuals. Not sure, all right? Myself, Congressman Evans, and our mutual good friend, Senator Booker, both are participants in the same Ballhead Brothers Club. And so we have one perspective on the matter, okay? But let me just say this, believe it or not, I'll be brief, and I will not even invoke former Mayor Street's line, no matter how long it takes. This is about discrimination. This is just simple. It's about everything else that was discussed, clearly about everything else that was discussed. But in its simplest form, this is about discrimination against individuals who choose to be themselves, and live their lives as themselves. And that is what we cannot tolerate. We cannot accept discrimination against individuals who choose to be themselves, to live their lives, and especially in this case, to live their lives in the context of their history and our culture. And that's why we're going down this path with this legislation. It's not complicated, all right? It calls from history, it calls from culture, it calls from the specific experiences that my colleagues have mentioned, Chastity Jones and Andrew Johnson and Kitty Harris and Asia Simu and so many more, all right? And so many more that have not gone reported, but have been make sure, and we thank you for the hearing, is that we want to make sure that our voices are heard. And our voices are heard at the federal level, at the state level, at the local level. Because people who are being discriminated against usually don't have a voice, usually don't have a place that they can turn. We are their voice. And if they see us speaking up for them and their circumstance and their situation, maybe that will strengthen them in the pursuit of their own life, in the realization of their own culture. So I want to thank you. In our last conversation, I think it was the press conference that we had, and one of our next panelists admonished me because I only spent, her name is Ajwa, I only spent 8 hours in the African hair braiding salon with my wife in West Philadelphia. Only 8 hours, okay? Only 8 hours, all right? While my wife was getting her work done. Interestingly enough, I never got a chance to finish that story. About 3 weeks later, we had the privilege, responsibility, if you will, to travel to Nigeria to participate in many of you will remember Leon Sullivan's African American partnerships, those trips, bringing both communities together. And so when we arrived in Nigeria, my wife, being who she is, felt the need to get her stuff tightened up. Y'all know what I'm talking about, okay? Squilla and Evans may not know, but y'all know what I'm talking about, okay? And so consequently, in Abuja, in Nigeria, I spent another 6 hours watching my wife get her hair tightened up, okay? Now, maybe it was because we were in the motherland. The Philadelphia experience was 8 hours. The Nigerian experience was 6 hours, okay? And maybe that's just because history, culture, what have you. But all that being said, I add a little context and a little bit of brevity to something that is very serious. Discrimination is unacceptable and is up to us to pass the laws, to enforce the laws, but at the same time give voice to those who are being discriminated against because they may not have the voice and we need to strengthen them in this fight. Like Representative McClinton, we're in session right now, so I'm gonna have to dip out. Excuse me, I'm gonna have to leave real quick. All right, Ajra knows what I'm talking about. To go ahead and go to session, but I just want to thank you, Council Member, because once again, your voice and this partnership, teaming up with the effort that we're moving in Harrisburg, what the Congressman is doing in Washington, what you're leading in City Council, has greater importance than I think we all realize. So thank you very much.
Thank you so much. I know the three of you have said that you have to go, but Councilwoman Cindy Bass is on and she wants to be recognized. Please, before you all go, I want you to hear what Councilwoman Bass has to say. And if there are any other members of council who want to be recognized for this panel, just please type your name in the chat box. Chair recognizes Councilwoman Bass.
Thank you, Madam Councilwoman. I just really wanted to thank all of the panelists for their testimony, and to add to the conversation, I was particularly moved by State Representative Joanna McClinton's conversation regarding being professional. And I do recall being employed at a well-known bank in Northwest Philadelphia for many years. And I just wanted to share a very brief story about how one of the bank vice presidents made a statement, why can't they wear their hair professionally? And so the idea of braids or natural hair or anything other than a straight look was considered unprofessional. And one of the things that we have to recognize is that people will try to mute you in so many different ways. And that's people who look like you and people who don't look like you, who will really try to mute, particularly Black women, and getting them to assimilate is one of those ways that, people try to put us into a particular box. And so anyone who knows most Black women, we refuse to be muted by anyone when we got something to say. So I just really wanted to thank you all for your testimony, especially the state representative for her testimony as a Black woman who has gone through and experienced this kind of discrimination that I also experienced in working for a very well-known bank here in the city of Philadelphia many years ago. And so this thing is real. It does happen. And I just thank God that her supervisor, her direct supervisor, was someone who was enlightened and who, checked her on this particular matter. So, she was required to go to some, internal processes to make sure that she never had that kind of mistake again. And that's all very, very important because our hairstyles are really an expression of who we are, our cultural identity. And, they really do speak to us as individuals. So I just really wanted to thank our panelists for their testimony, and it's very powerful, and have a wonderful day. Thank you very much for being here.
Thank you, Councilwoman Bass. And please don't leave yet, the three of you. Councilmember Derek Green is asked to be recognized. Chair recognizes Councilmember Green.
Thank you, Madam Chair. As a member of I used to have the club, which includes Senator Booker, Congressman Evans, Senator Hughes. Councilmember Squilla is still hanging on a little bit.
Yeah.
Myself. I want to thank Majority Leader Parker for your leadership, as well as Representative McClinton and Senator Hughes, as well as Congressman Evans. On the state level, I'm curious from both Senator Hughes or Representative McClinton, what has been the reception by others in your body? I would hope that at the federal level, under the leadership of Congressman Evans and Speaker Pelosi, we would get a bill passed that would support this type of initiative. But at the local and state, more the state level, what has been the reception to this type of legislation?
I said real quick, at the federal level is passed the House. The Congressional Black Caucus under the leadership of Karen Bass from California. So all 55 members of the Black Caucus, and it sailed through, I should say to you. Matter of fact, the former chairman, Cedric Richmond from Louisiana, was the catalyst from his perspective. I've been there all the way, so I'm sharing with you. The House at the federal level has passed it, is now in the Senate. Senator Booker, others are trying to do what they're trying to do there, but it's definitely passed the House.
So in Harrisburg, nothing is sailing right now. That's prime sponsored by a House Democrat. But, you know, we got a few days to see other opportunities. I'll just leave it there. So that being said, it has started a conversation that has not been happening in central Pennsylvania. I've had several interviews with local TV where they asked me to share, you know, why is this needed? Why is this necessary? We know most of Pennsylvania is rural, so these experiences that we're describing, they're not so much of a priority. So we've started the conversation, and Senator Hughes will tell you we're wrapping up session, although we expect to be here in November. So we don't know how quickly it can sail, but the fact that it started a conversation, even about things that I've experienced as someone who's currently wearing a natural hairstyle in this Capitol, from my colleagues, the feedback, the comments that are unsolicited, you know, that's important because it will move the needle and we'll get it to the place where we can get it out of committee, especially if things continue to progress for us with the dynamics of our numbers, so we can be like DC and have it sail.
Just to add and just to close it out, Councilman Green, and again, you are also one of the members of the Baldhead Brothers Club, and the elected Baldhead Brothers Club. You know, look, we're in session. I think we're concluding session as Representative McClinton has indicated. But what we're seeing now is a broader public conversation about this, and a broader public conversation, and I think in spaces where people are much more comfortable with having this dialogue. There's only a few of us who are old enough in this Teams conversation that go back to the 60s when it was all about the Afro, and in those days, and believe it or not, I have pictures of mine. All right, and I'll forward it for evidence. Okay, in those days, it was a tremendous pushback on that. But we also remember the pride in an Angela Davis or others that we all felt, and I would sense and hope that we're in an environment right now, after a little bit of organizing and a little bit more public conversation and more communities. I believe the city of Pittsburgh is taking this issue on, okay? And more communities grow to be receptive to this, that this will evidence successful legislative activity in the future. And I would just say this, on today being the last day to register to vote in Pennsylvania. Elections matter. Elections matter, all right? And who represents who in either Washington or Harrisburg or city council, all of that matters. And if you want your issues expressed, if you want your culture expressed, if you want to stand up against discrimination, you got to be registered, votespa.com, and then you got to vote on November 3rd. And hopefully, as Representative McClinton and I are all working so hard, that change will be coming to Harrisburg, which will make it possible to have our legislation become the law of the Commonwealth of Pennsylvania. And we certainly pray change is coming to Washington, D.C., Congressman Evans. I'll give you that for sure.
I'd like to real quick add my voice to the senator and the representative. And I thank the councilwoman for conducting this here, because the Councilman Green, it is the collectivism of what you see here. This is, to my knowledge, been around a little while, never historically ever happened. State, federal, city, councilwoman driving this. So in my view, the senator is correct. Today's October the 19th. Register, November the 3rd, vote. Don't make any excuse. You must vote. There's a direct connection. So voting matters and black vote matters. So the reality is, as Senator and the representative said, what it all comes down to is it's not complicated. This is not complicated. At the end of the day, if you want to make a change, as I said to you, the late John Lewis said, if you see something that's wrong, stand up. And the fact of the matter is, since Councilwoman Sherelle Parker and the rest of you on that committee are having this hearing, having the state representative and the state senator collectively, it will happen. I'm not rosy glasses. I'm just telling you, it will happen when you use power to demonstrate you want to see it happen. That's
Thank you again.
And Madam Chair, if I could just...
No, 1 second. I know you have to go, and the three of them have to go. Councilman Green is going to finish up his comment, and Councilwoman Helen Gim just asked to be recognized in the chat box. So I don't want the three of you to leave before she has had an opportunity to speak. Chair recognizes Councilmember Green.
Yeah, I will close. This issue is so important just in based on how we as African Americans want to represent and not be discriminated against. Also, it ties into small businesses. When you think about braiding salons and other entrepreneurial activities, if we're being discriminated against in how we wear our hair, we also know that discrimination also occurs for those small businesses that will allow us to do so. So that's part of a conversation that I know is also happening in Harrisburg. Thank you all for your leadership. Thank you, Madam Chair.
Chair recognizes Councilmember Gim.
Thank you so much, Madam Chair. I'm just going to be incredibly brief because I know we have Dr. Blay and some other wonderful people coming up. But I also just wanted to thank everybody. Representative McClinton, your words were extraordinarily powerful. And as a member of the Women in Red Club, just want to say, gratitude for all of this. But also, Councilwoman Parker, I think one thing that this gives us an opportunity to remind us is that, as Congressman Evans says, this is a collaborative effort. If we want to see these things move in DC and in Harrisburg, but at the local council level, we can be your partners in driving this change. Use us as your signs of success. There's no fear. There's only uplifting people, seeing rights expand, having young people and children feel more confident and healthy and growing in their understanding of their place in this world. So, I think that many of us have seen, this partnership of federal, state, and local, especially when things are sometimes stuck a little bit. We will emphasize to the congressman and to the state representative that hopefully they will be stuck temporarily and that we will see new changes and new opportunities to see things move at the state and federal level. But thank you very much, Councilwoman Parker, for your leadership on this, and especially showing the power of local work in advancing many of these great things that can move at the state and federal level too.
Thank you so very much, Councilmember Gim. Is there anyone else interested in questioning this panel? Let me say a special thank you, Congressman Evans, Democratic Appropriations Chairman Senator Hughes, Democratic Caucus Chairwoman Joanna McClinton. Thank you so very much for taking the time to be with us today and on the record. Senator Hughes, were you counting the days? Is there a number? How many days? I mean, they're all running together. Is it 16, 15, 8? How many days is it now? Put your fingers up, Joa. How many is it? 10
or 15? Real clear. I'm like Joanna. I want to be real clear. The only number that matters to me is 4. Okay? That's the only number that matters to me. And I think the Joanna side of the building, the number is 9. All right? And all of you enlightened individuals can figure that one out. All right?
Thank you all so very much for your testimony. We greatly appreciate you.
Thank you.
If there are no other questions for this panel, I'll ask Rachel to please call the next panel, please.
The next panel is, we're going to have Dr. Yaba Blay go first because she has to leave, followed by Adjoa Asamoah, and then Professor Wendy Green.
Got it. Listen, we want to say a special thank you for you all. We had this schedule, Ajoa, for you to go first because you have clearly been the national leader in this. But let me say to Dr. Yaba Blay, we know that the timing, right? And we've got to wait for all of the technical kinks to work themselves out. And we know you have to go. So we want to give you the ability to give your testimony because we know you'll have to leave. And the panel, we'll ask them to stay because we want them to answer questions. So Dr. Blay, if you would state your name for the record and please proceed with your testimony. You're on mute, Dr. Blay. I'm sorry, you have to start over for us. We saw your lips moving. We just didn't hear anything.
How about now?
Now we can hear you. Thank you.
Good afternoon. My name is Dr. Yaba Blay. I am a scholar activist. I'm a professor, and I'm a cultural consultant. And my work focuses on the lived experiences of Black women and girls with a specific emphasis on our lived experiences and specific emphasis on body politics, which includes skin color politics, colorism, as well as what we are now calling texturism, hair politics, especially. And so when it comes to Black hair and Black hair practices, it is crucial that we recognize our hair and what we do to and with our hair as part of a long history of cultural practices that contribute to our sense of identity and well-being. And in that way, the discrimination that we face and the various ways that we are asked to, if not forced to, comply with the quote-unquote rules and regulations around hair essentially requires us to operate according to cultural norms that are foreign to us. I've been asked by a variety of brands, organizations, and government sectors to consult more recently on issues related to hair discrimination. And oftentimes, unfortunately, my advice is only taken with a grain of salt, if there is such a thing, only to the extent that they are willing to discuss the issue of hair and texturism in such a way that it makes the majority more comfortable. I want to advise, if not remind us all, that change does not happen in a comfortable place. But if it's change that we are truly seeking, then be prepared to be uncomfortable. When I teach body politics, particularly as it pertains to and impacts people of African descent specifically, I always contextualize the issues within the context of and through the lens of global white supremacy. Now, that term alone makes folks uncomfortable because when you hear white supremacy, your mind only goes as far as to think about white supremacists, such as the Ku Klux Klan. But I use the term global white supremacy because it draws our attention to the historically perpetuated, systemic, and institutionalized ideology about which people have power and which people do not, about which people should have power and which people should not. Said differently, global white supremacy is a system designed to maintain the belief that white people are superior to all other people, and that the ideas, thoughts, attitudes, appearances, and actions of white people are also superior to all other people's ideas, thoughts, attitudes, appearances, and actions. Global white supremacy sets standards that position whiteness as the norm and thus require people who are not white to adjust to whiteness in order to approximate whiteness. Rarely, if ever, are white people asked to or required to adjust their way of being. Rarely, if ever, are white people asked to change their hair in order to be accepted. White ways of being set the standards for everyone else, and herein lies the problem. Hair discrimination has long-lasting impact on a person's health and well-being. Perming natural hair or relaxing natural hair often results in hair breakage, hair loss, infections. Our hairstyles, our natural hairstyles like dreadlocks, also referred to as locks, braids, plaits, twists, afros, as well as extensions and hair ornaments like beads and barrettes that little Black girls love to wear and swing, the beads and barrettes that their mothers love to gift to them. Those styles often present as quote unquote too ethnic, quote unquote too Black, quote unquote too African. And this bias, dare I say this racism, often leads to discrimination in the workplace. Women who choose to embrace their natural hair also face unfair treatment and pushback for not wearing their hair straight, especially in the workplace where it is deemed quote unquote unprofessional and often turned into an offense in the workplace environment. Black women are 1.5 times more likely to be sent home from work because of their hair. Black women are over 80% more likely to report being judged more harshly on their looks than other women, and Black women are 80% more likely to change their natural hair to fit in at their office. And speaking as a professor who has taught at predominantly white institutions as well as historically Black colleges and universities, I can attest to the fact that we are out here training our students away from themselves, particularly in the business school model, where we might say you have to dress a particular way or speak a particular way, or if your name is too Black, right, too recognizably Black, that you might want to use an initial and your last name instead. And in the case of hair, we are literally teaching Black girls, Black college students, that they need to change the appearance of their hair in order to get that interview, in order to get that job. And again, I'm always faced with that question of who else has to deal with this? Who else is being trained away from themselves for the scope of success, if there is such a thing? So it makes me, of course, think of the Clark doll studies in the 1950s that were used in the case to desegregate our schools. And so many of us would like to believe that that was so long ago, but those tests have been re-implemented time and time again. And we continue to see, as recently as 2020, that Black children continue to select white dolls as the dolls that are seen more beautiful, that are seen more acceptable, that are seen as the dolls that are more good. So again, to reiterate that these issues have impact on all of us, and not just those of us in the workplace, but our children as well. So to reiterate, we are the only race, the only culture to be consistently told that we are not acceptable as we are, that we are not, quote unquote, if we present ourselves as we are. This way of thinking, this way of functioning has lasting impact on our lived experiences. And so I urge you to support this bill, to support this movement, particularly in this moment when so many institutions are giving lip service to the idea that they support diversity, equity, and inclusion. Remember that diversity, equity, and inclusion are so much more than words, that you have to operationalize those words, because what you value, you do. Thank you very much.
Dr. Blake, again, we know that you have to go, Dr. Yaba Blake, but we want you to know that we appreciate your sharing, your intellectual prowess. We know globally, the rigorous academic lectures, training, and research that you've done on this issue across the globe. And again, not just the texturism that you just referred to, but the colorism and everything that comes along with it, Dr. Blake. We want to say thank you. Again, we know that you will have to go, but if you could stay on as long as you can, just in case my colleagues have, because my colleagues may have questions, and Lord knows, Ajwa and Wendy, y'all gonna have to hold it down by yourself. And look, I know you guys are, capable, more than capable, but just be prepared if Dr. Blake has to go for any questions from my colleagues. Thank you so very much.
Thank you.
Thank you. Ajwa, we're going to ask you to state your name for the record and proceed with your testimony. And I do need to state for the record, we have seen public relations activity relative to the Crown Act across the United States and across the globe. As a matter of fact, I can think of some very well-known brands who have picked up the issue and wrap their arms around it. I've seen a lot of pictures of a lot of people celebrating when this legislation was passed locally and at the state level when it's been introduced and as it's being pushed at the federal level. The one thing that you haven't seen, because it is not the way she operates, is the young lady who has been a part of the nucleus of it all. She's done the work and then stepped aside when it comes time to take the picture. And so, Aurora, I want you to know that we appreciate it and we recognize your leadership. Please state your name for the record and proceed with your testimony.
Thank you so much, Soror, and to be joined by our other Soror just makes this, even better. My name is Ajwa B. Asamoah. Good afternoon, Chairwoman Parker, Vice Chair Green, and distinguished members of the committee. As I just stated, my name is Adjoa B. Asamoah, and as a proud alum of Temple University's African American Studies Department, and as the racial equity champion and political strategist who developed the legislative strategy for the entire nationwide Crown Act movement on behalf of the Crown Coalition, co-founded by Dove, it is my honor to testify in full support of your bill, Bill number 200252. There is a long-standing history and problematic practice of racial discrimination based on hair in the United States. There have been countless cases where Black people have been discriminated against for wearing natural hair and or protective styles, including but not limited to braids, locks, twists, bantu knots, afros, etc. This prevalent form of discrimination includes being fired, passed over for promotions, and even having employment offers rescinded. It impacts the upward mobility of individuals and families, and it has been the reason far too many of our children have missed school and had negative educational experiences. As I think about the work we've done at the local, state, and federal levels, I think about a dynamic student, Faith Finity, in Louisiana, who was sent home in tears because she wore beautiful braids that were deemed a violation of school rules. I think about DeAndre Arnold in Texas, who was told he could not participate in his high school graduation ceremony with his friends due to his locks couched in length, a display of his cultural pride. I think about people representing several ethnicities across the world collectively who I believe gasped witnessing Andre Johnson, a student wrestler in neighboring New Jersey, be forced to make a decision he should have never been tasked with making, to choose between having his locks cut and his identity attacked or forfeiting a match he had earned the right to participate in based on his talent. The African aesthetic is beautiful and it must be lifted and valued. The issue of narrow beauty standards in America continue to perpetuate unfair scrutiny, injustice, and discrimination in workplaces and schools against Black people, and it warrants a legislative fix. Whether you wear your hair natural but blown out like mine is today, or twisted like I wore it last week, or in locks, or in braids, or in an afro, our right to rock our crown how we choose must be protected. While some anti-discrimination laws currently protect the choice to wear an afro, we know that afros are not the only natural presentation or style of Black hair. Your bill, number 200252, will ensure protection against discrimination based on hairstyles. I personally work with and support elected officials on the Crown Act in more than 20 state legislatures across the country to outlaw hair discrimination, including Senator Vincent Hughes and Representatives McClinton and Lee. I have co-authored multiple bills at the local, state, and federal levels and worked directly with Congressman Cedric Richmond and others to pass the Crown Act in the United States House of Representatives, and I am working directly with Senator Booker to ensure it passes in the Senate. I've worked with legal experts, including those at the NAACP Legal Defense Fund on this work, and will continue to work tirelessly to advance racial and gender equity. As I prepare to close, I just need to note that for the past few years, I have worked with 5 Black women behind this movement. And in the spirit of ensuring Black women are recognized and properly credited for ensuring Black public opinion informs policy, I just need to say the names Kelly, Orlena, Marcy, AC, and Melanie. On behalf of the entire Crown Coalition, including over 70 civil rights and civic engagement-focused organizations, including our sororities, the National Action Network, the NAACP, and so many others, we value and thank you, Chairwoman Parker, for championing the Crown Act in Philadelphia and pledge our support to ensure this bill passes.
Thank you, Adjoa, of facts. It's so important. You know, I'm a certified secondary English teacher by profession, right? So I'm anal when people are talking and they say something and they don't attribute the quote to whom it really belongs to. That kind of stuff gets under my skin, in a real personal way. So thank you for saying those names on the record. Again, please don't leave. My colleagues will have questions, and I want to make sure you all are here. Wendy Green, Professor of Law, Drexel University, Thomas R. Klein School of Law. Thank you, Wendy, for being with us. State your name for the record and proceed with your testimony.
Well, thank you so much, Madam Chairwoman and Soror, for this opportunity and this privilege to be able to speak to you today in support of this legislation that is near and dear to my heart. And I'll have to say, extremely proud of it because I am now a new resident of Philadelphia, Pennsylvania, as being a part of the law faculty at Drexel University, Thomas R. Klein School of Law. And just wanted to say thanks to my co-panelists, esteemed co-panelists, Dr. Blay and Adjoa Asamoah, for setting the stage for this very important conversation that we'll have. Again, as you mentioned, I am a professor of law at Drexel University, Thomas R. Klein School of Law. I'm one of the legal architects for the Federal Crown Act that Adjoa just mentioned and others have mentioned as well, in addition to state-level Crown Acts. I am a founder of the hashtag Free the Hair movement and the author of a forthcoming book, hashtag Free the Hair, Locking Black Hair to Civil Rights Movements. For over a decade, I have published in an authoritative body of legal scholarship on what I've coined as grooming codes discrimination. And in this capacity, I've served as a legal expert, not only as it relates to the Crown Acts, but also racial discrimination cases challenging natural hair bans in workplaces and schools, including those that have been mentioned before as Chastity Jones' case, as well as DeAndre Arnold and Kaden Bradford in Texas, who were denied educational opportunities on the basis of their locks. As one of the nation's leading scholars, legal scholars, examining this civil rights issue, my scholarly and public advocacy have been instrumental in creating civil rights protections against race discrimination, like the bill under consideration today. And just as a personal and professional note, I've devoted my career to not only activating these legal reforms, but also elevating public awareness around the world as it relates to the harms of unchecked discriminatory grooming policies. For example, grooming policies that denigrate African descendants' natural hairstyles as distracting, extreme, excessive, unkempt, and unprofessional. Grooming policies that are often informed by negative racial stereotypes that systematically deprive African descendants of employment and educational opportunities and systematically result in our stigmatizing and dehumanizing treatment in both public and private spaces. And in the case of Black women and girls, these grooming policies require us to either cut off our hair, to cover our hair, or to wear our hair straightened. The latter is usually achieved through toxic chemicals, extreme heat styling, wigs and weaves, which are expensive and time-consuming to maintain. These long-term use of chemical relaxants, heat styling, wigs, and or weaves often causes temporary or permanent harm, as Dr. Blay spoke to earlier. It is common for us to suffer through chemical burns while chemical relaxers are being applied to our scalp and our hair, which are not only excruciatingly painful, but they are severely damaging. And I have to say on a personal note that I have been one of those individuals who have suffered those excruciating scalp damage due to burns, chemical burns. Black women and girls often endure hair breakage, balding, as well as scalp disorders like alopecia due to these chemical relaxants, as well as wigs, weaves, and extreme heat being applied. Something that people often don't know is that research even indicates potential correlations between hair straightening products that African descendant women commonly use and our increased chances of developing uterine fibroids, hormone-related infertility, and more aggressive forms of breast and uterine cancer. Studies even indicate a possible linkage between chemical relaxants and increased hormonal activity amongst African descendant girls, which in turn exacerbates these reproductive health issues that I've just mentioned. Therefore, natural hair bans leave African descendant women and girls in a precarious catch-22. Either you don your natural hair at the risk of lawfully being deprived of an employment or educational opportunity, or don straight hair at the risk of enduring consequential harms to our psychological, physical, and physiological well-being. Currently, this harmful bind, where many African descendant women and girls find themselves around the world, honestly, is lawful in 43 states due to what I call a hair-splitting legal distinction that federal courts have created. Shortly after the 1964 Civil Rights Act was enacted, federal courts adopted what is known as the immutability doctrine. This immutability doctrine limits the scope of legal protection against racial discrimination to discrimination on the basis of immutable, unchangeable racial characteristics, presumably like one's skin color. Applying this misguided doctrine for nearly 40 years, federal courts have repeatedly declared that when an employer denies an African descendant a job because she adorns an afro, the employer engages in unlawful race discrimination. However, the moment she twists, locks, or braids her afro and suffers adverse treatment on those grounds, the employer's discrimination is magically lawful. This bill before you today cures this unjustifiable gap in civil rights protection for African descendants who suffer natural hair discrimination, a pervasive form of racial discrimination that harkens back to the eras of racial slavery and apartheid in this country. For nearly 4 centuries, like our skin color, African descendants' hairstyles resulting from our curly or coily hair texture have served as a marker of our racial identity and therefore a vehicle of racial enslavement, racial segregation, and racial subordination. Indeed, an early American jurist declared a woolly hair texture, or a hair texture that had the propensity to become woolly, signified African ancestry or Blackness, and where an individual's straight hair texture signified European ancestry or whiteness. Therefore, in the context of racial slavery, a person could be consigned to enslavement solely on the basis of their woolly hair texture or the propensity of it becoming woolly, and the straightness of one's hair could legally render a person free. In the 21st century, one's exercise of freedom still remains connected, unfortunately, to the texture of our hair. Race-based natural hair discrimination is a common barrier to African descendants' employment and educational opportunities, as well as our access to public accommodations and housing. However, this bill, also known as the Crown Act before you today, I have to say, helps to rectify this centuries-old state of affairs. It makes clear that systemic discrimination African descendants endure on the basis of our natural and protective hairstyles, like we have endured on the basis of other race-based characteristics, such as our skin color, constitutes race discrimination. So I thank you today for your collective leadership to all of those legislators, including yourself, Chairwoman Parker, for your collective leadership on this very important bill. And I strongly urge you to be on the right side of history by joining your fellow lawmakers across the country in advancing this legal reform, which clarifies that racial discrimination consists of discrimination on the basis of characteristics that are historically, contemporarily, and commonly associated with racial identity.
Thank you all so very much for your testimony. Wow, like we could write a dissertation just based on your testimony, the three of you. Let me ask you, if you will, I'm gonna ask my colleagues to who wish to be recognized just to please put your name in the chat box. I want to ask you, Adjoa and Wendy, tell us about, so I was so appreciative of Senator Hughes, along with Representative McClinton, to talk about the journey that they're going to have to travel through in the Pennsylvania General Assembly. Now, fortunately, I've had the great experience of serving there for 10 years. And sometimes some folks like to think when they're here in City Council that the way we can get legislation moved, I'm talking about the timeline, the swiftness with which we can move, I don't know that they make the connection at the state level. It's a whole another space. Tell us about, if you will, since you all have been working with this on a national level, what has it been like in other cities? Are other cities moving? And are you working with the National League of Cities, NACO, or any other organizations on this legislation?
Do you want me to start? Okay, sure. So what we've done is we've brought together so many different organizations. I shared just a few of the names. Of course, the co-founders of the Crown Coalition include Dove, Color of Change, the National Urban League, Western Center on Law and Poverty. But we also brought together organizations that are our historical civil rights organizations, including the NAACP, National Action Network, in addition to other organizations, including our Black sororities and the African American Mayors Association, the National Black Caucus of State Legislators, National Organization of Black Elected Legislative Women, the Association of Black Psychologists, and so many others, including the U.S. Black Chambers of Commerce. And bringing together over 70 organizations at this point, and it continues to grow. What I have found as the legislative strategist is lawmakers recognize that essentially you all work for us until we decide you don't. And so part of what we've done is ensure that it is known that there is a collective, a groundswell of support around this bill. We've clarified what the bill is and what it is not. Some people think that the bill interferes with OSHA standards and regulations, et cetera. It does not. So we've created an FAQ. We have showed up to provide testimony like we do here, like we're doing here today. Done the same thing nationwide, essentially in terms of strategy, started on the West Coast and the East Coast, with New York actually passing the bill first, California introducing the bill first, and then New Jersey was already ripe for it because of, sort of the national attention that was around that particular issue. And in the legislative world, once you have 3 states, you have sort of a movement. And together, working with my colleagues who understand the need to include the press, because the press, the mainstream media, was not talking about this issue in the way that it is now without us coming together. So as someone who uses the language, it takes a village, but as someone who has actually lived in a village, I can say definitively that it's the collectivity around this. It's the Black women and men showing up. You see that I worked with 2 men in the Congress. Neither one of them are on the receiving end of hair discrimination. But while it disproportionately impacts Black women, it absolutely impacts Black men. And we are inextricably linked. We are all required to protect our babies. And so, again, it's really the collective effort that has made this movement so successful, with the support of so many people across a number of different spaces. And so, again, just sort of clarifying what it is, what it's not, and why this bill is critically important and must be passed. That has proven to be successful. The movement, for me personally, is not just about shifting policy, but about shifting both policy and culture. And with all of the support, we're doing exactly that.
Wendy, any comment? You want to add anything?
Oh, sure. I think, to all of what, Adjoa has just mentioned is really critically important. I think what has happened with this legislation is that it really has helped to uncover, probably some miseducation as it relates to not only Black hair and Black hair textures, but also as it relates to the scope of civil rights protections related to natural hair discrimination. Many individuals often think, a couple of things. Many individuals often think that it doesn't exist, or they're just unaware of the systematic and global nature of race-based natural hair discrimination. They are not aware of the history around, the longstanding history around this discrimination that African descendants uniquely suffer. And additionally, they are not aware that our federal civil rights laws currently do not prohibit race-based natural hair discrimination. As I mentioned before, many people are not aware of that immutability doctrine that demarcates this again, what I call a hair-splitting legal distinction. They often think that natural hair discrimination is already covered under our federal civil rights laws, or that it's already covered under maybe our state or local anti-discrimination laws. And so what I know for a fact is that the proliferation of this conversation that has been, activated by not only the Crown Act and local measures such as the New York City Commission on Human Rights Enforcement Guidance, local ordinance such as these, has really helped to elevate the conversation. But what I will say is that even prior to that, when we've had almost 40 years, at least since the Civil Rights Act of 1964 was passed, 40 years of litigation around this very issue at the start. And people don't really realize that almost at the very beginning of this passage of this seminal civil rights statute, that Black women and men were challenging natural hair discrimination as a form of race discrimination. And unfortunately, our federal civil rights laws have not protected it as such, except for in the cases of afros. The other point I wanted to make really quickly is that what this bill does, yes, it is centered around African descendants, right? And rightfully so, around African descendants, very much as we see when we passed the 1964 Civil Rights Act. But what it doesn't bring about special treatment for African descendants. It actually brings about equal treatment for African descendants and equal treatment for everyone who suffers or endures discrimination on the basis, racial discrimination on the basis of, say, mutable or changeable characteristics like our hair, like our skin complexion, like the clothes that we wear, like our names, and like, even our accents or our language. It equalizes our civil rights protections against race discrimination. And I think all of this legislation and the collective movement around it has really helped to educate people as it relates to this.
Thank you. Dr. Blay, any closing remarks before we conclude with this panel and begin with the next? I want to thank my colleagues as well for their patience.
No, I'd just like to give thanks to both Ajwa and to Professor Green for their testimony, for their work. As they've both alluded to, this is work that we've all been doing for a long time, but also a life that we've all been living for a long time. And so I'm honored to be a part of the movement, and I prayerfully, our words will not fall on deaf ears, and there will be victory. So thank you.
Thank you all, and I know the three of you better pick up the phone if we need you and we call you back again. Audra, we're going to let you have closing remarks because we have to start the next panel.
Thank you so much, and we always have your back. While I didn't know that I was supposed to wear red today, ironically I did, and it's fitting given our connection on a whole nother level. I only just wanted to acknowledge one of our others, and that is Congresswoman Marcia Fudge. It was during her tenure as chair of the Congressional Black Caucus that the Black female members of the caucus, they all signed a letter that was penned and sent to the then Secretary of Defense to calling out essentially racial discrimination based on a proposed ban on certain hairstyles. So I just again wanted to get that in and acknowledge that they took action as lawmakers even before I became a part of this movement. And the only other thing I would note, and then I will be quiet and let you all get about the business of your committee, is it's important to note that while Wendy talked about how people don't know, there are some people who actually do, not by lived experience, but just by the idea of being dismissive. 8 state legislatures have passed this bill. However, it has only been enacted in 7. One governor actually opted to veto the bill. So that is willingly saying, I am acknowledging that you all have passed something and said that it is critically important to you, and I am going to then assert my authority and veto it. So I just wanted to put that on the books, that some people know, some people don't, and we have to work collectively to ensure that it passes independent of intention.
Again, thank you all for your testimony. I don't see any questions in the chat box for this panel, so we want to thank you all. And I'm going to ask the clerk to please call the names of the members of the next panel scheduled to testify.
Thank you.
Pamela Gwaltney, Sarita Scott, Muga El-Tagani, and Joanne Bell.
Pamela, we're going to ask you to just state your name for the record and feel free to proceed with your testimony.
Good afternoon. My name is Pamela Gwaltney, and it is my pleasure to be before you today virtually to add my voice to the chorus in support of Bill 200252. Chairperson Parker Soror, it's a pleasure to be here along with a company of other sorors. I am very proud, and if I had a shirt on, I'd be busting buttons. So it's my pleasure to be here today to add my voice. As you may or may not know, the Philadelphia Commission on Human Relations is the first municipal civil rights agency. And we were established under the Home Rule Charter, and we administer and enforce all laws prohibiting discrimination. We also resolve community conflicts, and we promote equality and understanding throughout the city of Philadelphia. Over a 69-year period since 1951, we have been out in the streets and been a consistent voice working for fair and equal treatment of residents and visitors to our city. We enforce and educate the public about Philadelphia's civil rights laws. There are 16 plus categories protected under our Fair Practices Ordinance, and those include race, national origin, religion, sex, sexual orientation, gender, identity, and disability. If I wore my hair braided, that would make me no less qualified or incapable of doing my job. I should not be harassed if I decide to grow my hair into locks or to wear any other protective or texture-enhancing hairstyle. It is already known that discrimination based on race, on sex, on sexual orientation, on gender identity, religion, disability is unlawful. But imagine not being hired because an employer doesn't like the way you wear your hair or the texture of your hair. Imagine not being served in a restaurant or not being able to hang out for the evening with your friends at a popular restaurant or nightclub because your hair is banned in a dress code policy. These acts of discrimination occur, and because of this, the PCHR supports amending the Fair Practices Ordinance, the FPO, to clarify that discrimination based on hairstyles and texture is unlawful discrimination. Voting for this amendment will be instrumental in putting an end to these unlawful behaviors in Philadelphia's bill, clarifying protections under discrimination based on characteristics such as hair texture and hairstyles is unique because our protections under the Fair Practices Ordinance would offer protections to individuals beyond employment and educational settings. The bill would provide comprehensive protections in the areas of housing, in the areas of real property, employment, public accommodation, and the delivery of city services. So it's all around protections for individuals. I'd like to talk a little bit about our neighboring states and what they've done to advance Crown legislation. Lawmakers in New Jersey advanced their Crown legislation and celebrated their victory of having the law signed by Governor Phil Murphy on December 19, 2019, which was exactly 1 year from the date, the anniversary of the wrestling match, where that young Black man had his locks cut in front of everyone. So everyone's heard a lot about that. There was a lot of press about that. But I think what you need to hear is a little bit about what the coaches and other officials in that scholastic athletic organization had to say why they made their decisions. When later asked to explain why they did what they did, one of the wrestling coaches stated, "They're dreadlocks. They're not in their natural state." Other comments made about that incident were that his hair was abrasive and it was altered, and that it was believed that the hair was not, again, in its natural state. These comments show the lack of knowledge about Black hairstyles and display misconceptions and often fear about Black hair and textured hair. In the Memorandum of Understanding between the New Jersey State Interscholastic Athletic Association and the New Jersey Division on Civil Rights, which is New Jersey's civil rights agency, they penned following the filing of this civil rights complaint. It was determined that some New Jersey wrestling officials interpreted a rule on hair that traditionally Black hairstyles were unnatural or subjected the wrestlers with traditionally Black hairstyles to differential treatment. In the New Jersey Division on Civil Rights Guidance on Race Discrimination, which they wrote as a result of that case, filed with them, they released it in September of 2019. It explained that New Jersey's law against discrimination's prohibition on discrimination based on race encompassed discrimination that's ostensibly based on hairstyles that are inextricably intertwined and closely associated with race. The guidance explained that the LAD generally prohibits employers, housing providers, and places of accommodation, including schools in New Jersey, from enforcing grooming or appearance policies that ban, limit, or restrict hairstyles closely related with Black people. And we already know what the list of those hairstyles are. We want to talk about the first state that did this, California, but I'd also want to give a nod to the New York Commission. So California was the first state to introduce Crown Act and sign the bill into law. And that happened on July 3rd of 2020. It marked the 1-year anniversary following their passage of their law. And New York and New Jersey soon followed. The pioneering guidance issued by the New York City Commission on Human Rights set forth that bans or restrictions on natural hair or hairstyles associated with Black people are often rooted in white standards of appearance and perpetuate racist stereotypes that Black hairstyles are unprofessional, and we've heard about that today. Such policies exacerbate anti-Black bias at school, while playing sports, and in other areas of daily living. I think what's important to understand, and I believe that Mysora Green pointed that earlier, is that when we make hairstyle discrimination unlawful, we're not only helping folks of color, Black and brown folks, but we are also extending those protections to other individuals. You should know that on October 16th of 2020, the New York Civil Rights Commission held their online public hearing last week on its proposed rule on discrimination based on hair as a form of race and religious discrimination, and it was widely attended. So the New York Commission's groundbreaking guidance provides that framework for all of us by which other states and municipalities can afford these very same important protections in civil rights. So back to Philadelphia. So right here in Philly, with the clarification that unlawful discrimination includes discrimination based on characteristics such as hair texture and hairstyles under the FPO, we, the PCHR, would undoubtedly see an uptick in these cases filed with us. In fact, we'll be looking forward to them. Among the cases previously filed with us was a case where a young man who was denied access to a nightclub because he wore his hair in locks. So we're hoping to get more of those kinds of cases when people go out and about and they find out that that kind of treatment or that kind of discrimination is unlawful. So as I close, I want to remind you that discrimination based on hairstyle is synonymous with racial discrimination. Bill 200252 makes it explicit that treating someone differently at work, at home, in the place of public accommodation based on hairstyle or hair texture is unlawful here. Philadelphia is a city of brotherly love, always a leader in the area of civil rights, the first municipality with a civil rights agency. We've got to step up and be among the first cities to, along with the 7 states, to pass Crown legislation and amend the Fair Practice Ordinance to afford protections against discrimination based on hairstyle and hair texture. Now is the time. I'd like to close with a poem written in April of 2013 by a young lady named Kalia Glover. I am the afro, thick, twisted, and heavy. I remind you of who you should be, aware of what you could be if you acknowledged me. Thank you for your time. I appreciate having the opportunity to be here today, and I'll be available to answer any questions.
Thank you so much, Pamela. I want to state for the record that we would not be where we are without you and Rue and the Philadelphia Commission on Human Relations. So I want to say thank you. Thank you so much. We're going to ask Sarita Scott, founder of Duafe Hair Salon, to state her name for the record and proceed with her testimony. You're on mute. You're on mute. Please start over for us. Did we lose you, Sarita? I see Pam. Did we lose her, Rach?
She's back in.
Okay, here she is. All right, okay. Thank you.
So much. Thank you. My apologies. So my name is Sarita Scott, and I am the owner of Duape Holistic Hair Care. I have been advocating for my brown, beautiful sisters for over 20 years, helping them feel a level and sense of comfort with their natural selves. And I want to say thank you so much, Sherelle, for allowing me to be a part of this conversation. My hair should not be up for discussion, discriminated against in the workplace. Thanks to the legislation of the Crown Act, I pray we can put all this behind us. We should be measured by our performance and skill instead of our aesthetics. These microaggressions in the workplace, schools suggest that if I choose to wear my hair in its authentic state, braids, locks, ethnic hairstyles, that I'm deemed unprofessional, incapable, last in line to be hired, not able to participate in sports, looked over for promotion or housing is insanity. My hairstyle should not bear my value. Place a glass ceiling over my head. When I was 20, an underwriter in corporate America, I felt the need to ask my manager if I was able to wear locks. My manager then responded to me, it was a matter that had to be taken up by upper management, to then soon find out that I was not allowed to wear locks in corporate America. Thank God for that experience, because what that experience allowed for me to do is quit. And I quit and I started Duape Holistic Hair Care because I realized that there was a large percentage of people who experienced what I experienced and they needed service. Sadly, in 2020, my natural hair is still a hot button topic. With this Crown Act creating a respectful and open world for natural hair, my hope is that my people are inspired to wear their authentic hair and they're protected from the degradation that I experienced in corporate America. Allow for me to give you context. Did you know that it was against the law for a Black woman to show her hair, thus the Aunt Your Mama head wrap? So we did not see the Black woman's hair until the early 1900s. And how we saw it was straightened. And the reason why we straightened our hair was to lessen the uncomfortability that we experienced during slavery. Or did you know that in Africa, we used to wear how we wore our hair deemed our social and our marital status. We knew who we were the moment or even before we opened up our mouths. And let's even talk about the pencil test that they used in apartheid. It was grim. Simply by that pencil sticking on the top of our hair stopped our movement, stopped our progression, and it literally put us in position that we lived in ghettos and we weren't able to live our best life. What's sad about this is day by day, I experience sisters coming in so many different lifestyles and so many different professions, and I spend my time giving them a large sense of comfort because of what they're experiencing in their day-to-day life. And that's just not in their workplace. It's just not in sports arenas. That's also even in how they're dating. Our hair, our aesthetic, who we are, has some reason to make people extremely uncomfortable. With this act, thank you, Sherelle, with this act. With this act, it is going to allow for us to walk in stronger, walk in taller, and we won't have to change our hair to simply go into any space or place, and we know that we'll be able to thrive in that. So I want to say thank you for everybody that's involved with this act. I want to say once again, thank you, Sherelle Parker, Councilwoman Sherelle Parker, for allowing for this to even be. And I want to thank every brown woman who decides to wear their hair in any which way that they want, because that is their God-given right. Thank you.
Thank you so much, Sarita. We've got two more people on this panel. If I chop up your name when you come on, founder and CEO of Natural Club, say Don't make me do it. Don't put me through. Don't torment me that way. Say your name out loud so I can repeat it and pronounce it correctly.
It's Mohja Al-Tajani.
Muja?
Yes.
Mucha, thank you so very much for being here. State your name again for the record, and please feel free to proceed with your testimony.
Okay. Good afternoon, Chairperson Parker, the Committee on Law and Government, distinguished guests, and fellow advocates. My name is Mohja Al-Tajani, and I'm the CEO of Natural, a natural hair care company. I'm excited to come before you today to exercise my voice to support Bill number 200252, which clarifies the unlawful discrimination includes discrimination based on characteristics such as hair texture and hairstyles under the Fair Practice or the City of Philadelphia's anti-discrimination law. At Natural, we encourage our employees to do their job with excellence in a timely and efficient manner. The styling of their hair does not affect their ability to do their job. I have employees with locks, braids, and afros, and their respective hairstyles do not make my organization any less professional. I too wear my clothes in a free-flowing state in the office, virtually for investor meetings and to formal events. There's nothing unkempt about taking care of your hair and wearing it in its natural state. Why is a messy bun appropriate at work for other races, but a protective style is not? This is a clear case of discrimination against women of color, and it is known that discrimination based on race, sex, sexual orientation, gender, identity, religion, and disability is unlawful. Imagine seeing your child denied entry to a private school because they have locks. This happened to 7-year-old CJ and his family in Florida. Imagine changing up your hairstyle and having your job security suddenly reduced because your employer does not like it. This happened to Chastity Jones in Alabama. Imagine being able to do nothing to change their opinions about the way you were born and that you are discriminated against due to factors such as your hair type that you had no control over. The Good Hair Study conducted by Perception Institute asked over 4,000 participants to take an online implicit associations test, which involves rapidly changing photos of Black women with smooth and natural hair and rotating words associated with both. According to the study, a majority of people, regardless of race and gender, hold some bias towards women of color based on their hair. The results also indicated that this bias is a learned behavior and can be unlearned. The study also concludes that white women demonstrate the strongest bias, both explicit and implicit, against textured hair. They rated it as a less beautiful, less sexy / attractive, and less professional than smooth hair. However, white women who are in contact with Black women naturalistas demonstrated lower levels of bias. Given that white women make a large majority of the 38% of female managers who decide what looks are appropriate for work, legal conflicts sometimes ensue. And courts tend to rule in favor of employers in such cases. Nolee Brooks, a professor at Cornell University, who writes about the intersection of beauty and race, says for some reason, naturally textured Black hair just frightens some white people. She said, quote, "I have yet to come across an actual court case where the texture of hair for another racial group has reached the point of a court case," unquote. Despite how much the natural hair movement is gaining traction, this has been an issue since Black Americans received civilian rights. Were you aware that the movement actually started gaining traction during the 1960s? The Black is Beautiful movement assured Black women and men that their skin, facial features, and natural hair were admirable, as is. Civil rights activist Marcus Garvey encouraged Black women to embrace their natural kinks, arguing that copying white or Eurocentric standards of beauty harmed the beauty of Black women. Quote, "Don't remove the kinks from your hair, remove them from your brain," unquote. Civil rights leader Angela Davis sported an afro as a sign of Black power and rebellion against Eurocentric beauty standards. Wearing an afro became a weapon in fight for racial equality, as well as a public declaration of self-love and solidarity within the Black community. While afros were technically allowed in workplaces, the social pressure to emulate Eurocentric hair permeated American society, impacting Black women's hair grooming decisions. In Hey Girl, Am I More Than My Hair?, the communication scholar Tracy Owens Patton wrote the quote, the progressive changes made during the Black Power movement eroded as assimilation became more dominant in the late 1970s and throughout the 1980s, unquote. Sparked nearly 4 decades later when the Crown legislation garnered attention, where lawmakers in our neighboring state of New Jersey celebrated the victory of having the law signed by Governor Phil Murphy on December 19, 2019, the 1-year anniversary of the wrestling match in which a Black New Jersey high school student's locks were cut off in order to participate in a wrestling match. If you are unfamiliar, a young Black wrestler had his locks publicly cut during a wrestling competition in late 2018. The referee told this young man that he needs to cut off his locks or forfeit the match. He opted to have his locks cut. The viral video of this happening garnered him a lot of praise for being a hero and the ultimate team player. But why? He was humiliated in front of his peers and community while having to forego years of growth just to play his sport. One of his coaches even claimed that they're just dreadlocks and they aren't in their natural state. This just shows a severe lack of knowledge and empathy about how Black hair works and behaves. Why is this? Why isn't the follicle shape of a curly and kinky hair common knowledge like straight hair? How many hair care commercials show a curly strand becoming moisturized? There's no reason for my products to be sold in the ethnic hair care aisle if there is no racial discrimination against certain hair textures. Natural hairstyles apparently only matter if the hair is straight. It's obvious that this is just a case of systematic racial bias against African Americans. I should have no reason to feel less of a CEO because I don't straighten my hair. A professional hairstyle should be determined by its texture. It should not be determined by its texture. A well-maintained afro is just as professional as a slicked back bun or ponytail, and any other ruling is perpetuating the racist ideals that made this such an issue in the first place. I started Natural to uplift and teach people that their natural hair is beautiful. That beauty isn't just left for those whose hair grows out of their head straight or who spend hours at a salon. We, as Black people, should be able to express ourselves and honor our culture by wearing our hair how we please. I'm going to repeat it once again, that well-kept hair is professional as straight and clean-cut hair. Thank you so much today for allowing me to testify before you. I hope you guys are staying safe. Thank you. And I'm here to answer any questions.
Oh gosh, I just got a text message from someone and saying thank you so much for everyone going through with their complete testimony, because we needed to get this formally and officially on the record here in City Council. So thank you so very much for your testimony. Concluding this panel, we're going to hear from Joanne Bell, the co-convener of the Black Women's Leadership Council. Please state your name for the record, Joanne, and proceed with your testimony.
My name is Joanne Bell, and I am the co-convener of Black Women's Leadership Council, and we also have a weekly radio of the same entitlement. To Councilwoman Parker and to Vice Chair Derek Green and the distinguished members of the panel, I am a woman of a certain age. And I recall sitting in between my mother's legs getting my hair done. Now, this story is very telling to me. She was halfway through. So I had one side that was after puffed, and the other side that she was struggling with me with the straightening comb. And I asked to go to the restroom. She found me 20 minutes late outside playing. I had enough of that. And so I got dragged back in. I struggled all of my life with the various different hairstyles that Black women had coming through the times. In freshman year of college, when we were sporting the afro, I was told that I stopped combing my hair. As life went on, I tried every style, spent hours in the hair salon, and the only place that I ever really enjoyed being was at Duape with Sharita Scott, who taught me, love your natural. She gave me different styles. One of them she gave me, I was afraid to go home. I didn't know how that was going to work in the job that I held. I'm a lobbyist, and I didn't know how my clients would like it, but they did. And so I want Black women to be comfortable in their skin, to wear any hairdo that they feel comfortable that they can wear. I do have a problem with the standard of that we are being told that we ought to accept. We should not have to parrot after being white women's standard of beauty. I think that we suffer self-esteem in some areas, and I am so proud today to be a part of a panel where I have met and seen so many wonderful sisters, because we're fighters. And so I'm not going to get into that long testimony that I thought I was going to have, because I heard it all from all of you. And what I would say is that I firmly support the bill, and I'm here for anyone who wants to ask any questions. Thank you.
Thank you so very much, Joanne, for your testimony. Chair wants to recognize Council Member Green, who has some comments and questions. Councilmember Green, are you still there?
I'm here.
Did you have a small business question or comment, Councilman Green, or am I mistaken?
Yes, let me just follow up. Thank you, Madam Chair. Thank you all for this panel, for your testimony and your advocacy, and letting people know, regardless of your type or braid of hair, that you should feel embraced and not feel diminished in any way. Ms. Scott, thank you for your entrepreneurial activities and your story, and how you started your business, Duafe. And my question is there any, well, before I go with my question, I'm going to give this perspective. My niece used to have a beauty salon on Germantown Avenue. She actually had two on Germantown Avenue near Germantown, Shelton. And I would often talk about with her, the importance of being politically engaged. And, at that time, I actually had some hair at that period of time. But I would talk about this because for some of our young professionals and those who were in that industry didn't really see the connection of how to get involved in politics. And I said, imagine if you were able to bring together all of the beauty salons just from Germantown and, let's say, Johnson to Germantown and Shelton. And you went to your state representative and said to that state representative, there are certain regulations and rules that are done in Harrisburg that impact how we run our business. And so that demonstrates the impact you can all have as entrepreneurs, as women entrepreneurs, in changing the narrative of how you do business and how regulations and policy impact you in your business. So my question is to Ms. Scott, are there a network of other business owners, especially in the braiding community, that have come together to start to advocate to make some changes in Harrisburg on some of the issues you see regarding regulations for your businesses? I know there's been some conversations. Senator Street has had some dialogue regarding that issue as well. But I'm curious, has there been any entity to kind of bring people together to address that issue?
No, not as of yet, but something that's definitely needed. A large part of, I know for me, just Duape, there's 600 to 800 people that walk through our doors monthly. What a great opportunity for voters registration. What a great opportunity to really know some of the laws and legislations that's happening that ultimately, affect community or the judges that we stand in front of. I feel like it would behoove us to all collectively come together and figure out how to be more active politically and in our community. So no, not as of yet, but I feel like you're tasking me.
Well, I'm just making that observation. I also just recently heard that a group of barbershop owners and beauticians have also challenged the General Assembly and the governor's office in particular provide some additional funding for their businesses who have been so disparately impacted by this pandemic, and to provide specific resources out of the unspent federal CARES dollars for barbershops and beauty salons around this Commonwealth. And we know here in Philadelphia in particular, these entrepreneurs have been really impacted by this pandemic. So hopefully this will galvanize other entrepreneurs like yourself to come together on how these issues impact you from a business perspective, but also helps to demonstrate why this legislation is important, because people should be able to present themselves the way they want to be viewed and not allow others to dictate how they should be presented. And who's to say what is professional or not? We could have a much longer conversation about professionalism in the workplace in reference to clothing styles and footwear, like flip-flops, but that's a separate conversation. But I want to thank all of you for your testimony. You've all provided great information. Ms. Bell, thank you for that history lesson. I will make sure that some of the gentlemen that we participate with in conference calls, make sure they are advocates for the Crown legislation. I know you know who some of those men are. But thank you all for this great presentation and information. And this will hopefully really inspire, especially young women, to be able to feel comfortable no matter what setting they're in a predominantly African-American setting or not African-American setting, to be comfortable in their own skin and in their own hair the way they want to demonstrate and present themselves to the world. Thank you, Madam Chair.
Thank you, Councilmember Green. And Adjoa, you just popped up on my screen. I can see you. And Sarita, you mentioned TAS. So we are formally, so listen, aside from being a legislator, I did say I'm a teacher, right, by profession. So what we're going to ask for, and you shall be getting this information from us by Thursday of this week, we are going to send everyone who participated in this hearing, in essence, what we are going to be considering a declaration of support for Philadelphia's Crown Act. Now, Adjoa, you did this across the nation, so I know you can do this with your eyes closed, okay? But we want you to reach out to your networks across the city of Philadelphia, and guess what? Not just in the city of Philadelphia, but in the 5-county region area, because when I hear Sarita talk about 600 to 800 people walking through Duafe every week, guess what? They're not just residents from Philadelphia, but they come from, near and some far. In addition to that, Sarita, we know that you've been fortunate enough to work with some of Philadelphia's most renowned celebrities over the years. We've read about you across the world. And when we send it to you, Sarita, we're going to ask you to dig into your bag. And we're going to ask you to ask them if they would lend their voice to this action. I mean, we want to see our Jill Scott saying PHL 215. We want the Crown Act. That would just be major. And Adjoa, all of the people that you have worked with across the nation, Wendy and Pamela, you and I, we'll just do what legislators do and let the people who work on the outside. And Joanne Bell, we just hope that the Black Women's Leadership Council, when you are on WURD radio station or having your conferences, that you alert Black women and other women and all people in the city of Philadelphia that we're advocating strongly for this issue and that we need their voices to be a part of it. Now, Adjoa, I'm seeing you. I will stalk you if I don't find you afterwards. But I hope that each of you will be willing to help us with that effort. And Audra, we will call you to help us put together some language. Rachel Meadows on my team will call you, and also she'll put together a call between you, Wendy, and Pamela to figure out the structure of how we should do it, and then we have to work on getting it out. So let me see a thumbs up if you're willing to partner and help us. Thumbs up, Joanne Bell. I can't see your thumb. You got to raise it high. All right, y'all better answer the phone when we call. Thank you so very much for this testimony. I don't see any more comments for this committee. That will. So I'm sorry. Did somebody have their hand up? Okay, no more questions for this panel. We want to say thank you again so very much. That will, and is there anyone else here to testify on bill number 200252? Hearing none, that will conclude the testimony on this bill. Thank you, ladies, again so very much.
Thank you.
Rachel, can you please read the name of the panel for our next bill?
Yes, there are two testifiers on bill number 200159, and that is Rue Landau and Tony Abada.
Rue, is Rue here? Thank you so much. Okay, I see Rue. Thank you so very much, Rue, for being here. Please state your name for the record and proceed with your testimony. And a special shout out to you, Rue. We don't get to work on the Crown Act if it's not for our partnership with you and your team. So I want to say that for the record.
Hey, Councilmember Parker, can I just start by saying I listened to every single word that just happened over the past 2 hours. You might as well just drop the mic right now. That was incredible. Thank you so much for everything you did. Professor Green, I get to see you in person. That is just wonderful. You're transforming the way we're doing city government right now. And that is, it's life transforming. It's amazing. It was the most affirming council hearing I've heard in so long. And if honestly, and to have my deputy, Pamela Gwaltney, stand up there, given her own life experience, it's, if we can't post-COVID, when everyone got to be their own selves at home, rewrite the script for what it looks like when they get back to work, then I don't know what we're doing. So thank you. That was incredible.
Please state your name for the record and proceed with your testimony.
Oh, sorry, I'm here for something else, right? So thank you. I am here.
Excuse me, Rue. Councilmember Gim, do you want to start now, or do you want to give remarks after they finish, Councilwoman?
I'll wait until after they finish. I know Rue's been here, so I want to make sure that they get a chance to speak first.
Okay, thank you, Councilmember.
Okay.
Sorry, Rue, please proceed.
Oh, no, please. Thank you so much. So thank you, Chairperson Parker and members of the Law and Government Committee for giving me the opportunity to testify in support of Bill number 200159 that clarifies and amends certain procedures pertaining to the Fair Housing Commission and provides for the adoption of regulations. I am Rue Landau, Executive Director of the Fair Housing Commission, the agency that enforces the Fair Housing Ordinance. Before I go any further, let me give a huge thank you to Councilmember Gim for introducing this legislation on our behalf. It's not the sexiest legislation in the world, but it does some very, very important things. Enacted in 1962, the Fair Housing Ordinance prohibits certain unfair rental practices by landlords and gives the Commission the authority to address unsafe and unhealthy conditions in rental properties through adjudicatory hearings, as well as through its investigatory and subpoena authority. Since 2017, City Council has put a spotlight on the eviction crisis that exists in our city. You have closely examined the impact of evictions and substandard housing on low-income renters and crafted many solutions to the problems. As part of those efforts, you've championed bills to strengthen the Fair Housing Ordinance by adding provisions ranging from good cause eviction protections to the recent emergency housing protection bills necessary for tenants to stay in their homes during the COVID pandemic while repaying any past due rent. All these measures have been effective at starting to tackle the eviction crisis, and as expected, have resulted in an increase in cases filed with the Fair Housing Commission. With a very small but mighty staff, we are extremely busy, especially since we have resumed holding hearings virtually multiple times a week. As with municipal court, far more landlords are represented by attorneys or members of their management companies at fair housing hearings than tenants. Not only does that scenario create an imbalance of power at our hearings, it adds more work and burden on the Fair Housing Commission staff and commissioners who spend a lot of time working to focus tenants on producing documents or evidence to support the issues alleged in their complaints. As you recognized in the passage of your landmark right to counsel legislation, when parties are represented at hearings, it is easier and more efficient for them to tell their stories concisely and with the proper supporting documentation. And having both parties represented at hearings is a matter of justice. For well over 30 years, non-lawyers, particularly paralegals from legal services agencies, have represented tenants at Fair Housing Commission hearings. Similarly, owners and landlords have been represented by members of their management companies. In August 2019, the city solicitor issued an opinion memo to the Fair Housing Commission in which he determined that it is lawful for non-lawyers to assist tenants in the presentation of their cases at commission hearings. The proposed amendment to the Fair Housing Commission before you today would codify that provision. Namely, it will allow non-attorney representatives to facilitate the factual presentation of a party's case at commission hearings. Making this formal and permanent in our law will help to ensure efficiency and justice. Similarly, formally codifying the Commission's ability to promulgate regulations is a necessary step for the Fair Housing Ordinance going forward. The Commission's procedures and interpretation of certain provisions of the ordinance should be clearly outlined in regulations so that parties and their representatives understand the agency's requirements and process. Thank you again for the opportunity to testify today. I'm available for any questions.
Thank you so very much for your testimony. Is CLS on the line with us?
I'm here. It's Tony.
Oh, hi, Tony. Thank you. Tony, please state your name for the record and proceed with your testimony.
Thank you, Council Member. My name's Tony Abada, and I'm here to testify on these proposed rules. I am a paralegal at Community Legal Services, and I help to represent low-income tenants in Philadelphia facing eviction. And I'm here to support the proposed rules to allow non-attorney advocates like myself to help tenants in administrative hearings before the Fair Housing Commission. So thank you again for the opportunity to testify. Just for some context, I often receive calls from tenants who need help with repairs. These include things like inadequate heat in the winter, a lack of running water, unsanitary sewage sometimes that overflows, to just name a few. Tenants are almost always desperate and just don't know what to do. So I help these tenants with basic repair requests, sending letters to their landlord, communicating with the landlord, requesting inspections from the city's license and inspections office. Unfortunately, in some of these cases, landlords operate their businesses by evicting tenants and replacing these tenants instead of making the repairs that are needed. However, as Rue was talking about here in Philadelphia, we have protections against this and other unfair rental practices. So landlords can't just evict a tenant for asking for needed repairs. So it's really important that we have the Fair Housing Commission that has sort of a forum that tenants can go to when they need help with this issue. So tenants can go and bring a complaint against their landlord. Let's see here. So the commission continues to be one of the only forums where a tenant can get really a fair shot at getting these repairs and then protection from eviction. So non-attorney advocates like myself have played a critical role in this complaint process. So I help tenants to navigate sort of the general process of getting a landlord to make repairs and also filing the complaint with the Fair Housing Commission. And many low-income tenants, especially people of color, do not have a positive experience with courts. So often this means tenants don't think of the court as somewhere to go to try to get some help. So now more than ever, as Rue was talking about, it's vital that tenants have the support they need to navigate these systems. Historically, the commission had allowed the practice of allowing some non-attorney advocates like myself to come with tenants at these administrative hearings. So under an attorney supervision at my office and following training, I would accompany tenants to the administrative hearing before the commission. Before the actual hearing, I helped tenants to gather facts and prepare information. This preparation facilitated the hearing process so the commission could identify what the unfair rental practices are. At the hearing, I helped tenants lay out a simple timeline and explain how the repair issues were impacting their health or safety. I also did things like printing photos and other documents to help present to the commission. I also helped the tenants sort of understand what was happening and facilitate communication. And this is very similar to what I do in other administrative hearings, such as appeals before the Philadelphia Housing Authority. So generally, I've seen that non-attorney advocates like myself sort of help tenants navigate their basic rights during these administrative proceedings. So to help highlight this, in one particular case, I worked with an older adult struggling to restore hot water and functioning plumbing to her small unit in Port Richmond where she lived. We requested repairs from the landlord, but the landlord wouldn't respond. I helped to sort of facilitate some communication, but then we eventually had to file a complaint at the commission. We had a hearing before the commission and we kind of reached an impasse. The tenant was having a very difficult time and was very visibly upset. So I believe without my help at that point, she was scared and confused, and she probably would have abandoned the process and just faced the eviction. I was able to help the tenant understand what the purpose of the forum was, along with her goals as a tenant. The commission helped to sort of reestablish communication with the landlord, and then we were able to get the repairs and the tenant to start to pay rent. The landlord also agreed to withdraw the eviction complaint in municipal court. And as we know, this meant one vulnerable older tenant was able to avoid eviction and a crippling court judgment. This was really only one case. There are many confused tenants out there facing the crisis of needed repairs alongside the threat of eviction from landlords. So these new rules before the City Council will permit other non-attorney advocates like myself to help tenants before the commission. Ultimately, this means more tenants will be able to better understand the process to get needed repairs, maybe even a shot at working things out with their landlord. So I'm encouraging City Council members to support these rules. Thank you for your time and attention.
Thank you so much, Tony. The chair recognizes Councilmember Gimp.
Thank you so much, Councilwoman, and thank you so much for to our chair, Rue and Tony. I just had a few clarifying questions just so we know what this is. And I think Tony and Rue, you said this very clearly, but again, just for the record, this legislation will clarify that supports that individuals already often receive from paralegals and other experts can be allowed in the Fair Housing Commission. Is that correct?
That's correct. This is not anything out of the norm. And there's plenty of precedent to show why it's needed and why it is lawful.
Yeah. And, you know, again, we so appreciate working with you and with CLS for the important work that you do. Tony, do you think you could speak a little bit about what kind of training that paralegals receive in supporting tenants through CLS?
For sure. In order to go to the Fair Housing Commission, we have sort of generally we field a lot of different questions about repair issues, and each of us as paralegals work under the direct supervision of an attorney. So each of our cases is reviewed with an attorney for both the strategy and just practical advice. So we go through that training in order to sort of give basic repair information and advice about sort of what's happening. And then it's when these cases come up or if it gets escalated, we go through an additional sort of review process with the attorney. So before we actually go and represent on like our first cases, we do go through a moot process where we actually role play what it looks like at the Fair Housing Commission, like what to say, when to say it, who are the actors there, what sort of our role is as like advocates.
It's helpful. Thank you so much. And then my last question is back to Rue. Without the support of a paralegal, I think we've heard how much of a difference it makes to have tenants have somebody with them. Someone oftentimes that they have a relationship with and that they can trust. I think we've heard at previous sessions when we talked about what it feels like just to kind of go into these official places around evictions where you'll see a bank of attorneys, as one young woman described it and said, none of them is going to be speaking on my behalf. if we did not have the support of paralegals, if those were not allowed, what are some of the challenges that a tenant might face as they're trying to get through the administrative process?
So my commissioners, luckily, it's an informal forum, and they are able to be very helpful with asking a lot of questions like you do in council to elicit certain testimony from the parties. The problem is the case can, if it was going to be a 20 to 30 minute case, it oftentimes will turn into an hour or longer. It's not that the tenant doesn't know what happened in the property, but you often file a complaint about 2 to 3 issues, and maybe you've been living there for 10 years. People come and they want to tell a whole story. They tell a whole story of what it was like when they first moved in all the way through now. They have 100 documents. You really only need to see 10. It's not that they're not telling the story, right? It's just that we need to focus the story on what the issues are now. So the commissioners are really helpful, and they're patient, and the staff tries to help when they can, but having an advocate there, having somebody who helps them with the factual presentation of their cases, to make it orderly, to decide what they should talk about when, help them out. Remember that they have a document on that. It just changes everything for us. And then oftentimes too, when the landlord's represented and the tenant's not, sometimes, especially now, it's been interesting during our Zoom hearings, there is a lot of time where they can be in a separate room together. And there's sometimes they'll try to negotiate a deal. That is when it gets especially concerning too, is just that the tenant's there alone, the landlord's there with a lawyer, and they're trying to negotiate a deal on what could be, no one knows yet what the commissioners are about to do with the case. So to all of us, it's so helpful. We can't thank the paralegal and the law student advocates enough. You're all wonderful, and we want both sides represented all the time.
Yeah, I think that's really clear, and I just want to thank you again for that. This amendment is about balancing and leveling the playing field on both sides. But one thing that's very clear for us, knowing about the number of cases that are moving their way through landlord-tenant courts and the rapid number of evictions, because they're speeding kind of through a process here. Despite some of our best efforts to create all these off-ramps, we really do need to have you move a lot quicker. People like just getting jammed up because of time. If we can make this process more helpful for tenants, get them focused more quickly, because some of these cases can and should be resolved, in as easy a manner as possible, especially when it deals with repairs, especially as we're getting into more complicated areas. We know that time needs to be spent on these things, not on sort of the paperwork and what are we talking about here. And so, again, we want to appreciate all the work of your commissioners, and Tony and CLS. Thank you for all the work that you do to get people feeling like this system, they have a fighting chance through this system. So thank you both very much.
Thank you.
Thank you, Councilmember Gim. Councilmember Derek Green.
Thank you, Madam Chair. I want to thank this panel for your testimony regarding this matter. I think it's definitely something that is definitely needed. Ms. Landau, we go back quite a ways, and I was reflecting on our Temple Law days when third-year law students had the opportunity to represent people, especially either in the public defender's office or district attorney's office, or in other matters where there's definitely a need for some type of representation. Tony, thank you for your work as a paralegal at CLS. This is an area that is also very important. It also makes me think of the work that has been done over the years by having counselors who are helping people in the mortgage foreclosure diversionary program, which came out of the work that our majority leader, myself, did regarding predatory lending so many years ago. One of my concerns I do have, and hopefully as we address through the regulations, because there's definitely a need for individuals who need representation, someone to be an advocate for themselves. There may be some who may raise the issue, this is the unauthorized practice of law, but there's a lot of other areas where you have a non-attorney advocate representing someone in a hearing process. But I do have some concerns, and maybe Ms. Landau, you can raise some perspective on this, and this can be addressed in the regulations. And I've seen this more, not so much recently now, but in years past, in front of the Zoning Board of Adjustment, where you had those who would serve as expediters and take advantage of individuals by saying that I can basically be your common law attorney or represent you in front of a zoning board and take money from people to help them go through the process. We haven't seen this issue as much recently, but in years past, especially in communities where there is some language possible difference. And is there a way you can speak to in drafting the regulations where you can possibly address that? Because I would not want to see a situation where those who unfortunately try to take advantage of those who are easily in a position of vulnerability and need some assistance, then end up paying resources to someone that says they can help them in a process when they're just taking their money. And when you have a new opportunity like this for representation, want to make sure that those who do the work, like Tony and others, are able to do it, and that those who try to take advantage of individuals are not able to do it as well.
Mm-hmm. Well, thank you for that. So paralegals at CLS in particular have represented tenants at the Fair Housing Commission for over 30 years. We went back and tried to count. And we think it's longer than that, but that's about as far as we've gotten back to. So it's nothing new, and that's great. And so it's just codifying a practice that's already existed. I think the other thing is that most tenants who do have cases at the Fair Housing Commission are low income, so they're probably going to the legal services agencies anyway. As you know, it's free to file a complaint with our office, but it's something definitely to keep in mind. And certainly as we've been quickly trying to beef up our website with the new emergency housing protection bills, maybe we can find a space for this to just let people know that there are resources for them out there, that this isn't anything they should be paying for. And, just to make sure, and now in particular, there'll be, maybe even more representatives available for them at free or no cost, or maybe even low cost. Thank you for that.
Yeah, I just don't know if there's any way in the regulations, and it's something that you can think through as a way of addressing that. Because whenever there's a new opportunity, you have people who just take advantage of others, and they will see this as a way of creating a new industry or some type of way of making money. And I just want to make sure that that's contemplated as you're doing the regulations. Yeah. Just brainstorming, not sure how I can think off of the cuff and drafting regulation where you can say organizations like a community legal services or other entities are the only ones, because you may have a son, a nephew who may want to represent their mother and aunt, and you want them to be able to do that. But I just want to make sure that we're thinking about those who may try to take advantage of people by starting to charge people to do certain things. And I especially in those communities in our city where there may be some type of difference in language.
Right. That's a great idea. Thank you so much. We'll really think about that. Thank you.
Thank you, Councilmember Green, for your comments. Are there any other questions or comments from members of the committee? There being none, Rue and Tony, thank you so very much for your testimony. And Councilwoman Gim, thank you so very much for proffering this legislation. I think Rue was right. It's not always the sexy stuff that we do right that's important and substantive that will help people, but technical adjustments, right, are also extremely important. So thanks very much for your leadership on this issue.
Thank you.
Thank you, Council.
Okay. Now I want to conclude the hearing and go into a public meeting. There being no further questions from members of the committee and no other witnesses to testify, I will ask if there's anyone else present in this hearing whose name we have failed to call and that wishes to offer testimony on any of the bills being considered today. Hearing none, I want to thank all the panels and witnesses for their participation today. We value your opinions. I now invite all panels and witnesses to please disconnect from the meeting before we go into our public meeting. We will now pause the proceedings briefly as multiple participants leave the hearing, and we're going to hear some people disconnect, so just be patient with us for a few seconds. Okay, we want to reconvene the public meeting. Rachel, will you please call the roll to take attendance? Members that are in attendance will please indicate that you are present when your name is called. Also, please say a few brief words when responding so that your image will be displayed on the screen when you speak. I know my colleagues are saying, wait a minute, we did this already. We have to follow the rules and regs per our chief clerk. So Rachel, can you please call that roll again?
Yes, Vice Chair Derek Green.
Present for the meeting.
Councilmember Councilmember Helen Gim.
Present.
Councilmember Cindy Bass.
I am present. Thank you very much.
And Councilmember Mark Squilla.
Present.
Those are the 5 members who are present right now, making a quorum.
Colleagues, thank you again. Thank you, colleagues. Let me make sure I'm not on mute. Am I on mute? Thank you, colleagues. Thank you so very much for that. You understand when DECA gives you the rules, we follow the rules.
Absolutely.
So, with that being said, this concludes the public hearing of the committee. We will now go into a public meeting to consider the action to be taken on the bills before us today. The chair recognizes Vice Chair Green for a motion on bill number 200252.
Thank you, Madam Chair.
Councilmember, could I just make a quick statement before we vote?
Oh, sure, Council Lady.
And that'll give time for Councilwoman Quinona Sanchez to come into the meeting.
Oh, okay.
That's all right. I wanted to respect everybody's time, but Councilwoman, I just really wanted to thank you as well for the hearing that you had. It is not often enough that we get to talk about something in City Council that impacts young people right now, and I really do hope that we are able to share that hearing out to many young people across the city. I think it's a great discussion and dialogue in government classes and in young people's student history classes about what it means to have the power to make change. I was blown away by the last couple of panels. I mean, I did it again. I want to respect everybody's time, but we had a set of women leaders who were at the forefront of their fields in psychology, in child development, in race justice and sociology, in the law, and in organizing and political organizing. And it was just wonderful and great to listen to them. So I just wanted to say and reaffirm again, as many of my colleagues have already done, it was a wonderful hearing. I really hope and intend to do on our end to share it with a lot of young people and with a lot of our educators and teachers, because I thought it was a wonderful insight into how we can talk about law, current practices, and the way people live their lives. And for young people right now, I think that means a lot. So thank you, Madam Chair.
Thank you, Council Lady Gim. Let me get back here. Chair recognizes Councilman Green for a motion on bill number 200252.
Thank you, Madam Chair. I move that bill number 200252 be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council.
Second.
The chair knows for the record that Councilmember Squilla seconded the motion. It has been moved and properly seconded that bill number 200252 be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council. All those in favor signify by saying aye.
Aye.
Those opposed? The ayes have it. The motion carries. The chair recognizes Councilmember Gim for a motion on bill number 200159.
Yes, thank you very much, Madam Chair. I move that bill number 200159 be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council.
Is there a second?
Second.
The chair knows for the record that Councilmember Bass seconded the motion. It has been moved and properly seconded that bill number 200159 be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council. All those in favor of the motion will signify by saying aye.
Aye.
Those opposed? The ayes have it and the motion carries. Before we conclude the meeting, I do want to note for the record that Councilwoman Maria Quinones Sanchez, member of the Committee on Law and Government, was here when we started our hearing and is in that roll call. We did do another roll call, and Councilwoman Maria Quinones Sanchez, just wave your hands in the air so people can just see you for a second.
Thank you so much, Madam Chair, and I apologize. I had to hop off and hop back on. I also want to just echo the sentiments. Thank you so much for hosting this important conversation.
Thank you. And so, Councilwoman, listen, we had to do a double roll call today, and I told the colleagues so they would know that it wasn't me just adding a layer. And Squilla understood. I said, when Decker gives you instructions, you do exactly what he says the way he tells you to do it. And so that's just what we tried to do. This concludes the business before the Committee on Law and Government today. I want to say a special thanks to all of my colleagues for your patience, for your engagement, and just for your participation in this hearing today. We work in one of the greatest legislative bodies on the East Coast for councils, and I'm proud of it. Thanks so much, guys. Have a good day.
Thank you. Great job,
Have a good
Madam
day.
Chair. Bye-bye.